Families and the law. Resolving family law disputes. Family law in Alberta is complicated, but learning about the law that applies to your situation is a good first step. This video is one in a series that talks about different parts of family law in Alberta. This video talks about the basics of resolving family law disputes inside and outside of court. There are two ways to resolve a family law issue. You and the other party can make your own agreement, or you can let the court decide. There are pros and cons to each process. Some benefits of making your own agreement are: you and your ex have more control over the process and the outcome. You can make changes to the agreement over time if you and your ex agree. You can turn an agreement into a consent order. A consent order is a court order decided upon by consent between everyone involved and submitted to a judge for review and signature. It is different from other court orders where a judge makes the final decision. Turning an agreement into a consent order means the court can enforce the agreement if one person is not following it. Making your own agreement generally takes less time and money than going to court. There are a few downsides to making an agreement. If you and your ex cannot agree on something, you may have to go to court to ask a judge to decide on that issue. Secondly, a court cannot enforce all types of agreements. There are many ways to make an agreement to resolve a dispute without going to court. A do-it-yourself agreement will save you time and money and gives you more control over the decisions you need to make, though it is a good idea to consult a lawyer to make sure your plan is fair and enforceable by the court. You and your ex can also work with a professional to make an agreement. You can work with a mediator, a neutral person who helps you work together to come up with an agreement that works for everyone. You can work with an arbitrator, person the parties appoint to make a decision instead of a judge. The arbitrator will make a decision that is in the best interests of your children. There is mediation arbitration, where a mediator has the power to make a binding decision if you cannot reach an agreement. And lastly, there are collaborative processes, a type of negotiation where both parties have their own lawyers but work together to find a solution without going to court. If you cannot come to an agreement, only then will you have to go to court. Going to court should be a last resort. Going to court means a judge makes decisions for you and your family based only on the evidence before them. The judge does not know your family. As well, going to court can become very expensive, especially if you and your ex do not agree on things or need to keep changing things. Resolving issues in court can also take a long time, months or even years in some cases. But sometimes it is necessary to go to court. If there is a history of violence between you and your ex, or you struggle to communicate with each other, going to court can make sure you are both on the same level. No one has the upper hand. As well, courts can enforce orders they make if someone is not following them. Before you go to court for a family law issue, you need to know ahead of time which legislation or law you should use and which level of court you should go to. Let's start with the laws. 3 laws are commonly used in family disputes in Alberta. The Divorce Act applies across Canada and is only for married or divorced people. It deals with divorces, but also with parenting and child support and spousal support. The Family Law Act applies only in Alberta. It's for married or unmarried people. It deals with parenting, guardianship, contact with a child, child support, partner support, spousal support, and more. The Family Property Act applies to married couples and adult interdependent partners who separated on or after January 1st, 2020. It deals with how to divide property when the relationship ends. Before the Family Property Act, we had the Matrimonial Property Act. It still exists, but it applies only to married couples who separated before January 1st, 2020. Now let's take a look at the courts. There are 3 levels of court in Alberta. The Provincial Court is the lower court. The Court of Queen's Bench is the Superior Court, and the Court of Appeal is the highest court in the province. Higher levels of court can hear appeals of decisions from lower levels of court. Appeals from the Court of Appeal go to the Supreme Court of Canada, which is the highest court in all of Canada. All family law cases must start in either the Provincial Court or the Court of Queen's Bench. You should use the Court of Queen's Bench if you are dealing with the following issues: applying for divorce, dividing property, applying for exclusive possession of the home or household goods, applying for a declaration of parentage, applying for a declaration of irreconcilability, asking for direction regarding holding money in trust or dealing with real property. You can use the Provincial Court or the Court of Queen's Bench to deal with all other issues. Sometimes you will use both courts to resolve your disputes, though not at the same time. If you are married but separated from your spouse and not yet applying for divorce, you can apply for parenting orders or financial support in the Provincial Court under the Family Law Act. When you do file for divorce, you must do so under the Divorce Act in the Court of Queen's Bench. From this point forward, you will only use the Court of Queen's Bench. And when it makes orders, the Court of Queen's Bench will look at orders previously made in the Provincial Court. If you are responding to court documents, you must do so in the same level of court where the original court document was filed. If you are applying to change a court order, you must also apply in the same level of court where the original order was granted. Each level of court has its own rules and processes. For example, the Provincial Court has less formal rules and so is easier for people to navigate through themselves if they do not have a lawyer. There are also more locations across the province. The Court of Queen's Bench, on the other hand, has fewer locations across the province, usually only in bigger cities. The court has more formal rules, and so more people are represented by lawyers. To start a court action in either court, you must file the right court forms. Each court has its own forms that you must use. There is one exception, though. Since both courts hear issues under the Family Law Act, they use the same forms for these issues. You can find the forms for each court on the Alberta Courts website at www.albertacourts.ca. Choose the level of court first, then choose Family Law as the area of law. When you file the first document in a court action, the court will assign you a court file number. All documents you or anyone else files related to the action and throughout the process will use this same court file number. Once you file documents, you usually must serve those documents on the other people involved. To serve someone means to officially give them documents in a way that can be proven to the court. There are different ways to serve someone, including in person, by recorded mail, by fax, or by email. For some documents, you must arrange for someone else to serve them personally on the other person. The people in a court action are called the parties. You might also hear the words applicant or plaintiff used to describe the person who starts a court action, and the words respondent or defendant used to describe the person responding to a court action. Sometimes you can be both. You might be the applicant for one issue and the respondent for another issue. Eventually, you probably want the judge to make a decision about something. The term court application refers to a request for a court order. This term refers to two things. First, it is the name of the form you file to make your request. Usually, you must also file an affidavit with this form. An affidavit is written evidence that you swore or affirm is true. The term application also refers to how the judge hears your request. Sometimes you will have to appear before a judge to make your application. Other times, you can submit a desk application, which is a written request using proper court forms where you ask the judge to grant a court order without the need for you to appear in court. Each court also calls judges by different names. In provincial court, judges are called, well, judges. You must address them as Your Honor, or you can address male judges as Sir and female judges as Madame. In the Court of Queen's Bench, judges are called justices. You must address male justices as My Lord or Sir, and female justices as My Lady or Madame. The Court of Queen's Bench also has masters who are judicial officers with authority to hear and decide on certain types of issues. Masters are not judges or justices. In a short video, we cannot possibly go through the entire court process. In fact, each case is unique, and so the process may be different for each person. Each court also has different services and supports available to help people resolve disputes. For more detailed information on this topic, visit www.cplea.ca/family.